Already today is July 18th. The time is about 5 p.m. every evening, every Tuesday evening at from 5 p.m. Central Time to 6 p.m. We do bring in immigration updates. Emily, what do we have today?
Sure. Today we want to talk about adjustment of status EADs, when you get them, when should you use them, what types of jobs can you do? Are there any restrictions on that? Does it matter if you're the primary applicant or if you're the dependent applicant? So we'll talk about everything to do with the EADs to make sure that you're maintaining your status. Also, switching universities when you're on an F-1 visa. What is the process? When can you do it? Are there any restrictions on that? Should you do it? Are there good schools, bad schools, that sort of thing? And then what to do when you are in H-1B status and are experiencing a layoff situation. What are your options for that? What is the timing that's involved? How does the 60-day grace period work? Especially there was just an article that came out from SHRM, the Society for Human Resource Management, about the time it takes to hire someone is approaching 44 days on average, and it's much longer, particularly for hard to fill positions in the tech sector. So how does the 60-day grace period work when it takes you over 45 days just to get through the hiring process of the new job? And then a common question that we get is for those that are in the EB1C category and have been able to file the 485, can you change jobs? What kind of job can you switch to? Are there any restrictions there? And lastly, with, again, the PERM processing times just continue to expand. They're just now working on September 2022 filings. What are your options if you're getting close to the H-1B 6-year limit and still waiting for the PERM approval?
So, Emily, with regards to EAD, I know there is a primary applicant EAD and the adjustment of status application, and the dependent EADs. We know that on the dependent EADs, there is no restriction, none whatsoever at all. They can flip a burger in McDonald's, they can be a Microsoft CEO, or they can be an immigration lawyer like me, which I at one point of time was on the dependent adjustment of status EAD. But on the primary EAD, what are the restrictions that are available there? When they switch the job, does the job duties have to be exactly the same? Can they be a little bit more complex than what they're already doing?
Yeah, so if you're using the EAD and you are the primary applicant, you have to remember that your whole 485 and that of your family is based on you always having a valid offer of employment for a full-time permanent position, and that if you are changing jobs, that position that you're being offered has to be similar to the occupation that you were originally sponsored for on your labor certification. Now, you can also have a second job, a side job, where you can do any kind of legal activity. But for the job that is supporting your 485, it does have to be in a similar occupation. It does not have to be the exact same job duties. It doesn't have to be the same job title. It can be advancing in your career. They do understand normal career progression over time. But you have to make sure that you always have that valid job offer that supports the 485. And then on the side, you can have another job offer. You can do real estate. You can invest in stocks. You can start a business, anything you want to do on the side, as long as you have that main job. And then, of course, remember, if you are wanting to continue your non-immigrant status, your H-1B or your L-1, if you're using the EAD to do side work, that means you're no longer in H-1B status or L-1 status, because that status only allows you to work for the employer that you're approved to work for. So if you're using your EAD, that takes you out of that non-immigrant status.
Speaking of University Assembly, I'm a bit concerned for some of the people who are coming into United States. They come for decent universities because it's very hard to get the stamping for not so good universities. So the students already know they normally get admitted to good universities. Once they come here, though, they try to change to universities that are not so good sometimes, which I'm worried about. The first thing is that you cannot change the university in the first semester. You have to attend the first semester. Then in the second semester, that's the time if you want to change the university, you can. But when you're changing the university, don't go to the short-term thinking, okay, this university is charging less fees. don't go for it, because eventually we see all the IT, especially the IT company, IT people, they make about $100,000 a year, which you can make the difference of the money probably in a month or 2 months income once you graduate though. So if I were the student, I should not be overly concerned about that. But if you want to change the university really for any good reasons, you can change the university after the first semester. You have to get admission into a different university, and then you have to change the civil system from University A to University B. We're also concerned about some of the people who are moving from good universities to day one CPT university. We strongly recommend don't go to these day one CPT universities. These day one CPT universities don't require you to attend the college. They don't require you to. They will give you work permit as soon as you join them. It looks very attractive for people who come into the United States, but there are long-term negative effects of these joining these kind of universities. USCIS has two sting operations on this. You must notice one is University of Northern New Jersey. They put an entirely fake university and got all the people, and they did a lot of trouble, the students who joined the university. And there was also Farmington University, where they deported almost like 600 to 800 people who ever joined Farmington University. These are fake universities where they have supplied day one CPT. Now, we also know that there are other universities, and we don't mind naming them: Campbellsville, Cumberland, Harrisburg universities. We recommend people not to join these universities. We don't consider the day one CPTs that these universities are giving are properly done. Because if you ask, a lot of people ask question, well, they are giving, why can't I take it? Well, there's a reason why they are giving. Look, there are 3,000 institutions that are allowed to give student visas. How many of these universities are giving the day one CPT universities? Hardly any 4 or 5 universities. The rest of the 2,995 universities, the universities like University of Texas, University of California, they don't give day one CPT universities. So that's an indication for you that don't fall into the trap of this. We have recommended people not to file multiple H-1B applications. Look what happened. They're getting deported right now. So this could happen to these day one CPTs. Don't join this day one university. Do you have anything else, Emily, before we go to the next topic?
Yeah, especially after you've already gotten into a good school and got your visa and come to the U.S., it's best to continue with the good school. That's what's going to help you in your career and your immigration going forward. Going to these day one CPT schools might allow you to work temporarily, but it's going to cause you more trouble on your immigration in the future, and we don't recommend that.
Emily, you said on the topic of the students, people switching from one job to another job, it's taking 45 days to intake a particular employee. Now we have these layoff situations where people are getting laid off, and it's taking time for the companies to get the jobs. I mean, it takes a little bit of time for them to search. Luckily, these people are in a very hard profession. Some of the people are finding the job. Some of the people are taking a little bit of time to find the jobs. So what are the alternative options for them if they don't get the job within 60 days? Everybody knows that if you lose the job, from the time you lose the job to the time you get to the new job, 60 days is a period that is there. But what are the alternatives? What are the advices that you give to the people? We're getting a lot of people coming into the daily conference call that we have, where people can come log in and ask 3 questions. These people ask a lot of questions, Emily, on this daily conference call.
Yeah, I think there's varying levels of options. Some are better than others. So probably your number one best option is to find the new job and file the transfer within 60 days. That's the easiest. Easier said than done, though. So if that's not an option, then you look at perhaps, is there another visa category that you qualify for? Most commonly, if your spouse has an H-1B, you can qualify for an H-4. If your spouse has the I-140, you can also get the H-4 EAD. So you could file a change of status to H-4 with an H-4 EAD, and then once that EAD comes in, can start work again for your new employer. And in the future, you can switch back to H-1B at any point by filing a change of status. That's the difficulty is the processing time, because if you're filing just the H-4 and the EAD by itself, It's probably 6 to 8 months to get that processed. There's no premium processing. But if the H-1B spouse is able to file an H-1B extension in premium or an amendment in premium, and then you can join your H-4 and H-4 EAD change of status to that application, then they can all be approved together in premium processing. So if the spouse's company is willing to file an amendment, even if it may not be necessary, you can file an amendment for any reason or no reason at all, just to be able to get that H-4 and H-4 EAD approved in premium. So that's usually the next best option. Beyond that, probably a B2 visitor visa change of status is going to be the next step. If you're nearing that 60-day mark and still don't have that transfer or have the new job lined up, the change of status to B2 can be filed online, the I-539 application, and you can request a 6-month stay. Usually the processing time is much longer than that. So while you're waiting, if you find that new job, then you can have the new company file a change of status back to H-1B, and USCIS confirms that if you file that in premium, they will adjudicate the B2 and the H-1B at the same time. So you'll go from H-1B to B2 right back to H-1B all in one step. Beyond that, the next option would probably be the I-140 compelling circumstances EAD, assuming you have an approved EAD. This is last on the list, mainly because it does not provide you with any status. All it does is give you a work permit and keeps you from becoming unlawfully present. But in order to get back into a status in the future, the only way to do it is by exiting the country, possibly getting a new visa stamp, and then coming back in. So that's why it's low on the list. Also, processing time is quite long for that. So those are the most common options for someone who's facing the layoff situation but wants to stay in the country while they continue to look for the job, even beyond the 60-day grace period.
The most often question that I receive, Emily, is that, hey, I'm coming near the 60 days. I got the job, but the company is taking longer time to file the H-1B application. I'm recommending them at this point of time to file a B2 application because you don't know how long it's going to take for the company to file it. It may be more than 60 days, and then you may have to leave the country. For that purpose, I'm telling them to apply for the B2 application and then look into how the H-1B is going to be processed. We have had no difficulties for those people who have filed the B2 application, then filed the H-1B application to get the H-1B transfer from B2 to H-1B, even though when the B2 was filed recently and freshly, we haven't had any difficulty in getting the H-1B approved. We don't have any at all. For those people who intend to file a B2 application, I normally recommend, you can fill an online application, you can file at any point of time. Typically, I tell people, hey, fill the online application, make all the notes, then probably consult an immigration lawyer. He will be able to guide you to get the B2 application filed online much faster. Do you need to file it like 40 days in advance, 30 days in advance? You can file 5 days in advance if you're filing online application. So that's an easy step to do it because then you'll get a receipt notice and you can provide it to the company. It will be easier for you if you apply for the B2 visa. Anything else, Emily, before we move to the next topic?
No, we can move on to changing employers if you have a pending 485 in the EB1C category. So that's the category that's similar to an L1, where you had to work for the company abroad for 1 year as a manager or executive. You're in the US working as a manager or executive. So is it possible to change employers to a company that doesn't have the qualifying relationship like you need for the L1?
Yes, Emily, you can. So if a person is working for, let's say, Cognizant, let's say if the person working for Tata Consultancy Company on L1A has filed the adjustment of status with Tata Consultancy Company on I-140 adjustment of status EAD, and he got the EAD approval, can he move to Wipro in a similar level position, even though he never ever worked for Wipro? The answer is clearly yes, he can move to Wipro, no problem with it. Even though he has never worked, even though the L1A requirement or the EB1C requirement is also that he must have worked for the company previously to coming to USA. But when it comes to porting from EB1C from one company to another company, he doesn't need to have worked for that company outside the country. All he needs to is that the position that he's going to be joining with the new company should be in the similar level as that of what he has been filed for the green card. But it is absolutely not required for them to have worked in a foreign country. Now, especially with the dates have been backlogged, Emily, a lot of these people have to stay with this company for like, I don't know how long it's going to take, decades or even longer. Do I need to stay with this company? Can I move out of this company? The answer is yes, you can move out of the company. However, there are a couple of things that I want you to be careful about. The 485 must have been filed more than 180 days ago, and your technically requirement is not, but it's a practical requirement, is that your EB1 I-140 should have been approved, period. It's not wise for you to move out of the company if the EB1C I-140 approved has not been, EB1C I-140 has not been approved. Emily, what about the situation in EB1B category, which is also employer specific? The person must be working for a research organization, working in a research field. Can they move from company A to company B in the EB1B category?
Yeah, so AC-21 is the law that allows portability of your 485, and it does also apply to EB1B. So outstanding professors and researchers can change jobs after the 485 has been pending for 180 days, as long as the new job is a similar occupation. So it doesn't have to be the same type of organization that sponsored you, but the position has to be similar in order to qualify.
Anything else, Emily, before we go to the next topic?
No, last topic. So what can someone do if their PERM is still pending and they're reaching the 6-year limit on their H-1B?
Multiple options. If they can spend a little bit time extra outside the country to recapture the time, as everybody knows that 6 years is the limit for the H-1B, but any time that you spend outside the country, you can deduct it. That's one thing that you can think about it. You can also think about it if you want to move outside the country. While you're outside the country, the company can still file the labor in I-140. Once the I-140 is approved, you can always come back into United States without subject to going through the lottery system. That's the second option that you can do. If you have a H-4 option, that's an option too. You can't work while you're on the H-4, while your H-1B are expired. But you can stay in this country while you're on H-4. The company can file a labor under I-140, and after the I-140 is approved, you can switch back to H-1B. The other option is that you can always file a B-2 application. We have had people where they are not eligible for H-4. You can file a B-2 application, get your I-140 approved, and then move back to H-1B. That's also one of the things that you need to consider. Especially right now, Emily, the PERM application is taking forever. I don't know, the things that are filed in September are getting approved. And you know, Emily, is that to file the PERM, we need to first get the prevailing wage. That is taking 7 to 8 months. Then after the prevailing wage is there, we need to do the recruitment, which may take anywhere between 2 months to 4 months. So 8 months, 4 months, plus almost like 10 months. It's almost like 2 years to get the I-140 approval in premium processing. So all those people who are waiting on the H-1B, don't come to us in the 6th year and, ooh, I'm in trouble. Come to us in the 1st year or 2nd year. We tell you the solution. You're here, you're listening to us. If you're in the 1st, 2nd years of the H-1B, go for the I-140 immediately. Don't wait for it. But as I suggested, going outside the country, H-4, B-2, and also spending a little bit time outside the country to recapture the dates are the options. Anything else, Emily, that you think are the options?
Yeah, I would definitely just recommend starting the process earlier than you ever thought you would needed to. I think a lot of people think they need to wait until they file their first H-1B extension. They shouldn't do it within the first 3 years. There's no rule requiring that. So as soon as you get your H-1B, your company can start the process as long as their policy allows it. So don't delay on that. And then if you find yourself in a situation, as you mentioned, where you're getting close to the 6-year limit, make sure you're aware of it early enough so that you can travel outside the US and back in and recapture that time. That's going to be one of the easiest ways if you don't have an option to change status to an H4 or a B2.
Let's go to question and answer assembly. The questions are coming from ES 350. That looks to be the Lexus model. Is that, are we expecting EB1 retrogression further? I am not expecting, but God knows what will happen about it. Questions with regards to, from Dhruvesh Babu. What happened to the investment business if someone has to move back to India? Is there any visa restriction? Absolutely not. You can invest in United States and you can get paid in United States. You can get the investment income in United States. You're subject to the income taxes for the income that you received in USA. But as such, there is no visa restriction. None, zero, zip. You can get paid. A lot of people ask the question with regards to 401k. What will happen to my 401k? You can keep as it is. You can withdraw whenever you want to, just like as if you're in USA. You're subject to the tax system, just like the way you are here in USA. But otherwise, there is no restriction, none whatsoever at all. And just for people to be aware of, what will happen to the Social Security if you did contribute for 10 years for the Social Security? They call it as 40 quarters. Well, in short form, it is 10 years. If you contributed it and then you go to India and you stay there, you are eligible for the Social Security. Once you hit that age, you will be eligible for Social Security. Depends on how much you contributed, you will be eligible for that much amount of money. Absolutely not required that you must be a green card holder or US citizen to receive the Social Security from India.
All right, here's a question from Bhagya. Is it true that a second H-1B lottery for this year is scheduled to happen this Friday? No, it's not true. We do expect a second lottery to happen given all the duplicate filings in the registration process and that USCIS still included those in the lottery. But there's nothing scheduled to happen at any particular time. In fact, they're still receipting the cases that were filed by June 30th. They were even cashing checks just yesterday of the filing fees. So I don't think they have a final count yet on how many they've received. Normally, when they do run a second lottery, it does happen between now and the end of July. So it might happen anytime soon, but it's definitely not something that's scheduled as of today.
And what are your expectations, Emily, about the second lottery? Will it occur?
I do expect it to occur, and maybe, I don't know, maybe 10,000 more might be selected, and then we'll see how many actually file, because if those include duplicates as well, they might have to do another one. They did do that the first year where there were two additional rounds of the lottery. I think this year is just completely unpredictable because of so many duplicates.
Question with regards to the Canadian open work permit for H-1B. We are not Canadian lawyers, Shyam, so we're not at liberty to comment about it. We actually don't know the laws of Canada as much as, I may know as much as you are. Probably you know better than me. Question from Senthil Kumar Govindaswamy. Is there a filing fees for renewal of green card EAD? No, zero filing fees. And also for the advanced parole, I-131, the filing fees is zero.
SS Rao says, is the grace period applicable if the H-1 gets revoked? Can you still transfer to another employer? It depends on what you mean by the H-1 getting revoked, because USCIS will revoke an H-1B if an employer has sent a withdrawal notice, because an employer, when you leave the company, is required by law to notify USCIS. And so if it's that kind of revocation where the company has informed USCIS that your employment has been terminated and then it gets revoked because of that, yes, the grace period still applies. You get the 60 days. If it was revoked because of some sort of gross error or fraud or misrepresentation, that's a different story. You would definitely need to contact an attorney, a qualified immigration attorney, to see what options you may have there, because that type of revocation may put you out of status.
Question that is coming on. I'm an L2 visa, moved on to H4 starting with October 1st. Can I change the status to F1 right now before October 1st? And yeah, absolutely, you can file a change of status to F1. Luckily, right now we have a premium processing, so you can apply in premium processing and get the F1 approved. So you're good to do that.
Yahoo filed the 485 back in October 2020 with a downgrade from EB2 to EB3, got the EAD AP still on H1B, and wants to know if he changes the work location to a different state and starts working remotely, does that impact the 485? So since your 485 has been pending for more than 180 days, I'm assuming your EB3 downgrade I-140 has also been approved by now. You qualify for AC-21. AC-21 allows you to change employers in a similar position, but it also allows you to move locations with the same employer. So no, that would not impact your 485. If anything, you can submit a supplement J form to update USCIS of the new work location, but it's not going to cause any issues since you do qualify for AC-21.
A question from Venkat Achanta from Facebook. 485 has been filed, EAD has been approved. Now the priority date has retrogressed. Can I now change the company? Will that cause any problem if I change the company? Absolutely, you can change the company. As long as you met the 180 days requirement, you can move to a different company at this point of time. With regards to the child is locked or not, it may be better for you to consult because we need to look into when your I-140 has been approved to see if the child is locked or not. Does the new company need to file a 485J supplement immediately? It's not required that they have to file immediately. We are recommending people to file it when there is an RFP or when there is an interview for the 485. Can the interview happen when the prior date is not current? Yes, it can happen, and it is happening.
Achanta says, do we need to wait till the 485J is approved to switch employers again, or is just filing the 485J good enough? There's no requirement to wait for USCIS to respond to a previously filed I-485J. Half the time they don't give you any approval or any kind of confirmation, probably more than half the time. So as long as you meet the 180-day requirement that your 485 has been pending and your I-140 is approved and the new job is in a similar occupation, you can switch jobs as many times as you want to without any waiting period in between.
Question from Aryansh Patel. His EB1 485 has been approved. Congrats on that, but unlucky for his family, they didn't get their green card. I guess it's the name I got confused, but the family did not get the green card. Now, the question is that, this is for Abhijit Sen, I'm sorry. The family did not get the green card. If they file I-130 for the family, can they switch the employment-based 485 to family-based 485? My advice to you is that file a 485 all over again, because it will take a decade sometimes, and believe me, it took a decade for me, to switch it from employment-based to family-based. Just file a fresh application. You'll be in a good position, though.
Vinod says that he recently switched from H-1B to using a dependent 485 EAD and wants to know how can he move back to H-1B. He left the job for the H-1B that he had and started 2 other jobs. So since you're no longer with that company, the new employer would need to file a new H-1B petition, assuming that you have not reached your 6-year limit, or if you have reached the 6-year limit, you have your own approved I-140. You can extend beyond the 6-year limit and you're not subject to the lottery. You don't have to go through the cap again. But because you're not in a non-immigrant status, that H-1B has to be filed for consular processing. So once it's approved, you would exit the US. If you already have the old H-1B stamp that has not expired yet, then you can just come right back using the old employer's stamp and the new employer's approval notice. But if your stamp is expired, you need to also go for stamping to come back to get a new I-94 that puts you back in H-1B status.
Aryansh Patel, I took his name previously, but I'm going to take his name correctly this time. His 485 changed to new card produced and the case is approved. What does it imply? Do I need to worry about retrogression because it won't be current in August. It implies that you got the green card 99% of the time. It is right. And if you get the green card by July 30th, though, even though the priority date moves backward, you don't have to worry about it. You're a green card holder. Congrats. Wish you best of luck.
Murtaza says, can an H-4 applicant travel during an H-4 transfer? So I'm assuming this is an H-4 extension that was filed along with an H-1B transfer. So as long as you were in the U.S. at the time the H-4 extension was filed, you can technically exit while it's pending. Again, I'm assuming this is an H-4 extension, not an H-4 change of status. If it's an H-4 change of status, if you travel while it's pending, your application will be abandoned. You need to go for H-4 stamping and come back and get the H-4 that way. But if it's an H-4 extension, you can travel while that is pending. If it's the first one has not yet expired, you can come back on the first one before it expires, or if it's already expired, then you're going to need the H-4 stamp, which you can utilize your spouse's H-1B approval notice to get the stamp to come back in.
Dhruvesh Babu has this question. What are the precautions people need to take who are on H-1B who want to invest in partnership business? One thing is that investment is different. Working for the company is different. If you are investing without any working, that's perfectly okay. But if you are going to be involved in the management of the company, then that is not allowed because you're on H-1B. You don't have a work permit to manage. So you need to be clear on what kind of investment that does it require your involvement, or is it just an investment? For example, if you're going to buy in the stock market, you most probably will not control what a Tesla is going to, Cybertruck is going to have a light or not in the front, or if they will have a side mirrors or not. You will not be in the control of it. That's perfectly okay. But if you're investing in a restaurant and you are going to sit there every weekend, that definitely is a work involved there. So those are the things that you need to be careful on the H-1B. Do you need to work, or is it just an investment with no work involved in it? As far as the proper investments, what is good for you, what is not good for you, though, well, we are not the investment advisors. I'm assuming that you only asked because of the immigration. We are only advising on the immigration. As far as the pure investment is concerned, we are not experts in it. We are not knowledgeable in it. You need to consult other people for it.
Sur says, I've lived in India for 3 months, came to the U.S., then went back again for 6 months. Can I add these multiple visits to India to pass the EB1C 1-year criteria? Yes, so you can combine. So what they look at is within the last 3 years, have you worked in a managerial or executive capacity for a company abroad outside the U.S. for at least 1 year? So you can combine multiple times outside the U.S. as long as it was in that 3-year period. But any time you spent in the U.S. during that 3 years does not count. So you have to subtract that.
Question from Siddharth Gautam. He has an EB1B EAD, EB1B. He crossed 180 days. Can he switch the employer? The answer is yes. Does the new employer need to file an EB1B I-140? No, they don't need to. Pending 485 is good enough. They may have to file a 485J supplement at one point of time. Can you switch the job field at a new job? No, you can't switch the job field. So let's say, for example, you're a biochemist. Can you become an IT professional and get the green card? No, you can't do that.
Srinivas said, I recently came to the U.S. 2 months ago and I'm planning to do a transfer, an H-1B transfer, but I don't have the pay stubs. Will there be any issue with my approval, and do you suggest premium processing? Yeah, there could be an issue with the approval because normally when you file an H-1 transfer, you have to show that you've maintained your status up to the time of filing the transfer, and that's through your pay statements. So without the pay statements, if it's been more than 60 days without you having any pay statements and then you're filing the transfer, you may end up getting a consular processing approval, meaning no new I-94, because they're saying that you violated your H-1 status by not having those pay statements. Then you have to exit the US and potentially get a new visa stamp and come back in. If it's within 60 days, so if it's less than 60 days, there's an argument that you could make that you qualify for the 60-day grace period. Maybe you came into the US and then the employer said, you know what, we don't really have work for you, we're terminating you. Then your 60-day grace period would start, and you could argue that you qualify to file a transfer within those 60 days, even though you don't have pay statements. But yeah, there's definitely a potential for getting an approval without an I-94 and having to travel in order to get back into H-1B status.
Can the dependent stay and the main applicant move to India? The dependent has a GCEAD. No, if the dependent is moving to India, the primary applicant is moving to India, the dependent cannot stay in USA. If the primary applicant is visiting India, it's absolutely not a problem, the dependent can stay. But if the primary applicant is moving, no, the dependent, because the whole purpose why the dependent is allowed to stay in this country is because to accompany the primary applicant. So that purpose is lost, the dependent cannot stay.
Arnav says, what is the process to correct the I-140 priority date? Can we request an I-140 amendment, and how long does that take? So it all kind of depends on what happened for them to issue you the wrong priority date. So maybe you have an old I-140 approval, and when you filed the next I-140, they didn't port the date. They didn't retain your old priority date. If the employer or their attorney submitted the information and requested that the date be ported and it wasn't, then the company may be able to contact customer service to get that corrected. And it probably is going to take 4 to 6 to 8 months because they're terrible right now. But if the request was never actually made, then it may actually require the I-140 to be filed again in order to get that date corrected. If it was something else, maybe you submitted the labor certification and the I-140 just came with the wrong priority date on it, that's something that a service request needs to be done. The employer or the employer's attorney are the only ones that can make that request, though.
The question from Suchai T. Landed in USA recently on H-1B. My employer A said I got no notice of intent to deny, but no proof was been given. Made H-1B transfer and successfully approved. Will there be any future problem? Is it NOID or is it not notice of intent to revoke? Because if you recently have come into USA with employer A, though, they're going to normally receive a notice of intent to revoke, not a notice of intent to deny. Notice of intent to revoke is after the approval. Notice of the intent to deny is before the approval. So I'm a bit confused. Did you come on company A or company B or company B? So I'm a bit confused on that. But coming to the point, though, if there is a notice of intent to deny or notice of intent to revoke, and if the employer is hiding the information, what is in there most probably is a very grave reason. We have been noticing recently the notice of intent to revoke is mostly for the internal projects, which we know what those internal projects are, or for the multiple filings. If either of those things, the H-1B has been revoked, though, we may have a problem. Even though your transfer has been successful, they may come after your current H-1B. Even if your current H-1B is with a company called Apple, they will come back to Apple and say that since your first H-1B is through fraudulent methods, the USCIS would like to revoke the subsequent H-1B with Apple. And they, even if they don't, when you want to extend the H-1B from Apple, or when you want to move from Apple to Microsoft, they will deny those applications. So yeah, once it's been revoked for fraudulent activity, either for the multiple filings or internal projects, you will be in trouble at a later date.
MB says he's a TN visa holder from Mexico and recently got the EB3 labor certification approved, the 9089 form, and wants to know, can my employer file the I-140 the next day after I arrive into the US? I'm concerned about non-immigrant intent. I can't say that I've done that. I usually do wait for some time. With the 9089, the labor certification, it is valid for 180 days from the date of approval. So we generally try to time travel within that 180 days so that we have enough time to wait for maybe 60 days after you enter and then file the I-140 petition. Because you're right, the TN is not a dual intent visa category. So having an I-140 filed immediately after entry could raise an issue. Now, there's also an argument that the presumption of non-immigrant intent or presumption of immigrant intent issue in the 90-day rule kind of all went away when they updated the Foreign Affairs Manual. But still, to be on the safe side, I would delay the filing for a little bit.
Jagdish Sumar has this question. If the candidate is currently an H-1B and received an EAD application, EAD through EB-1C, can they change the employer to a different employer by using the EAD through EB-1C? Yeah, absolutely they can. Just because they're an H-1B doesn't mean that they can't change, but subject to the condition that the 180-day rule has passed. I'm assuming that the EB-1C I-140 is already approved. The next question he posed was, does if the new job is in a different role, though, can it be in a different role? Is it okay? It has to be in a similar occupation. I mean, if it is in IT, it has to be in IT. You can't move from IT to a lawyer or a lawyer to IT, but within the same, you have to be in a similar role. For example, mostly EB-1Cs are very high-level executive positions. From high-level executive position, can you do just a simple software developer and then still get the green card in EB-1C? The answer is no. You have to be at a higher level position for you to get the green card in EB-1C. So the new position also should be in a higher level position. They don't have to file an I-140 again. And with regards to the 485J supplement, it's up to you if you want to file it, if you don't want to file it. When the RFE comes in, you have to file it. When the interview comes in, you have to file it, but it's optional if you don't have an RFE or if you don't have an interview. It's optional for you to file a 485J supplement, but absolutely not required for them to file another I-140.
ES350 has a non-immigration question that I want to answer. He wants to know if we actually have these clear blue skies in Houston, or is this a Zoom background? Actually, my office background. So yes, the skies are blue and a couple of clouds here and there, but it is 101 degrees right now.
Yes, I was about to point out.
5:45 p.m. in Houston, so
it's 101 degrees.
Pretty, but it does not feel pretty.
It is hot and muggy in Houston, guys. Here's another comment that I liked. It was that pray for Trump. Trump doesn't come in.
Yeah.
Betson George has this question. When can we expect the EB2 rest of the world to become current again? Well, we'll have to watch if the October visa bulletin may bring some changes. So we're not expecting any changes before that, but we may be expecting in October visa bulletin. We'll have to see in October bulletin how it's going to happen.
Krishna says, is there any restriction to book the H-1B visa stamping appointment using the receipt number without having the approval yet? Not that I'm aware of. I have had people do that more for L1s, but yes, for H's as well. As long as you have the receipt number, you can start the DS-160 visa application. You can pay the visa application fee. You just have to be careful to schedule your appointment after you expect to get the approval.
Krishna has this question that Krishna Parchuri has this question. The payroll is running from a different state than the LCA, a different location from the LCA. Will that be considered? Will that be a problem for stamping? Yes, absolutely. Especially if your payroll is running from Texas, let's say, for example, from Florida, but you are in Dallas. That's definitely. The LCA is in Dallas and payroll is running from Florida, that's definitely trouble. Or vice versa, it's trouble. But if it's a state, there are some states, like, for example, Virginia and Washington, D.C., they are like Maryland, every 5 miles, 3 estate changes. So that's fine if it's within 20 miles or 40 miles of the distance, it may be okay. But if it's a longer distance and your payroll is running from one state and your LCA location is, you need to contact an immigration lawyer immediately, your company's immigration lawyer immediately.
Kaluru says, how long are H-1B extension approvals taking nowadays with the IOE receipt number? So the IOE receipt number just means that they've received your petition and they've actually electronically scanned it and made it available to the service center, but it's still processed at one of the service centers. So you have to look at the bottom left-hand corner of your receipt notice. It will tell you which service center the case is actually at, even though they don't use the LIN or the VSC or the WAC prefix on the receipt number. That being said, I think the normal processing time right now is about 2.5 months. We are seeing them take longer than that. Some are shorter than that, but that's pretty standard these days.
Question with regard from Mr. Paul Reddy on EAD, working for 2 jobs. Should we inform the USCIS about the second job? No, you don't have to inform the USCIS about the second job. You're under no obligation to inform the USCIS under the second job. It's not required for you to do so. Emily, I want some discussion with regards to the comment that you made on the checks that are getting cashed recently that were filed before June 30th, though. How many more applications there may be? The reason is that until the June 30th data is inputted, they're not going to come with the next lottery, though.
Mm-hmm. So you're wondering how many are...
Yeah, do you have more checks that are still yet to be cashed?
Not a lot, no. But we're noticing it, that we're still seeing some checks come through. But definitely the majority of them we do have receipt notices for.
Yeah, and then Emily is of the belief of 10,000 more. I'm of the belief that it should be more. That's my guess. Let's see who wins as we go forward.
Let's see. Viraj has an EB2 priority date of January 2020. I'm assuming he is born in India. And he got selected for that new Canadian H-1B program that already had 10,000 people. They used it up in 48 hours. Wants to know, should I move to Canada for a few years and then come back? And will there be any impact on the I-140? So if you have an approved I-140 and you exit the U.S., that I-140 stays there unless the company withdraws it. But you get to have that priority date going forward. And as long as your I-140 has been approved for at least 180 days, you can use that I-140 in the future to get any H-1B, even if you're beyond the 6-year limit. But if you move to Canada for a few years, the question is your job offer that's supporting that I-140 still going to be available for you to come back? And if it's not, and you're changing to a different company, that new company has to file the H-1B. It would not be subject to the lottery. You get that approved, consular processing, get the visa stamp, come back in, and then the new company has to file a new labor certification, new I-140, then you can retain that old priority date and then file the 485.
The main question that is, as an immigrant from India, would you move to Canada rather than keep waiting here in the United States? If I were that person whose priority date is 2020, I am of a belief that I am going to move to Canada because I don't want to deal with Rahul Reddy or Emily for the next 90 years. That's very tough for me to deal. That's what my belief. Now, if the things change, you can always come back. Your priority date is already established. So 7-8 years down the line, you can always come back in H-1B. Since your I-140 is approved, assuming it's not withdrawn within 180 days, you can come back in the next 90 years at any point of time on H-1B, and you can retain the priority date. Yes, I personally, knowing what the immigration is, I am going to move to Canada. if I'm being given a green card there. Please don't contact our office about the Canadian immigration, guys. We don't deal with it. It's just our personal opinion. That doesn't mean that we practice Canadian law.
Lakshmi says, if I get a STEM OPT after my undergraduate degree, can I also get an OPT after my master's? Yes. So after you finished your bachelor's degree and it's a STEM field, you can get your 1 year of OPT followed by 2 years of the STEM extension and then go back to school for a master's. And you do get another 1 year of OPT, but you only get the STEM extension once. So you would not get another STEM extension after the master's degree.
Sam is asking the question, as a US citizen, can I sponsor for nephew and niece? No. You can sponsor for your sister or brother. And if their children are under 21, you can put them as a dependent and they will get a green card, assuming that by the time the priority date and all those things, they don't turn 21 under the CSPA age, they will still get the green card. But a standalone application for a nephew or niece is not allowed.
Viraj says, I have an I-485 EAD for me and my wife expiring this September. H-1B is expiring in July. Can I renew both the H-1B and the 485 EAD and AP? Because we want to use the EAD AP sometime next year. Yes, absolutely. They're completely separate from each other. So as long as your H-1B renewal is filed before it expires this month, you can do that. And you can have the 485 EAD and AP filed. They go to different service centers, different processes. So no issues with that at all.
Question with regards to, can a EAD and AP approved person stay in USA without doing a job until they get their green card? I'm assuming, Jignesh, you are the primary applicant. If you don't have a job, I strongly recommend you contact an immigration lawyer. There are some methods of self-employment, your wife employing you. They're risky methods, I'm not telling that. But if you don't have any job offer, technically you're not supposed to get the green card at all.
Betson says, I lost 5 months out of the 6-year limit when my H-1B was renewed. Can I recapture this time? So if you mean, so a lot of times that happened with the very first H-1B where because of the timing of the LCA, maybe you got it from October 1st, 2020, and it's only valid till May 2023 instead of September 2023. And then when you file your extension in May 2023, it's only good till May 2026. Yes, you can get those last 5 months that you missed out on because of that. But you do it at the very end. So you would file your 3-year, because you can't extend for more than 3 years at a time. So once you do your 3-year extension, then you can do your 5-month extension. And if you've already got the I-140 approved or your labor has been pending for 365 days by that point, then you can extend further in addition to those 5 months. You can combine those 2 extensions into one.
Shivkumar is sending, we're sending letters to USCIS, not count the family members. Can you guys discuss this during the conference with them? Well, we will discuss, but they won't listen to us, though. That's what we will discuss with it. We are also drafted a lot of letters for you guys. We need to put a lot of pressure on the USCIS, not counting the family member, but it has to come more politically from the congressman. Would be much better rather than just lawyers asking this question. Yeah, we will do that, Siva. On your request, when we go and meet with them and we get it, we'll ask them that question. Why are they counting the family members when the law does not stipulate to count the family members? But in the meantime, we request all of you guys to write letters to the administration to not count the family members at all. I also want to discuss about this family reunification, reunification process, where they are granting people whose I-130 is pending and they may get the green card in the next 17 years. They're allowed to come on advance parole and get an EAD here in USA. Why not the people who are waiting for the I-140 can get the EAD? What's wrong with these Indian people?
Yeah, especially for like L1s where you max out, you don't really have an option to extend. That makes total sense. Now, obviously, for H1s, they've given the option to extend beyond the 6-year limit when you have that I-140. But there's a lot of limitations to being on H1 compared to having an EAD and advanced parole. So, yeah, I think that obviously Congress is not going to act to do any major immigration reform. So we need to look for things that the president can do. The president does have the executive authority to create these parole programs. And they've done it time and time again over the last decades, and most recently just 2 weeks ago with this new program. So I definitely think that's something we should push for, in addition to stopping counting the dependents towards the cap.
They have done for Colombian, El Salvadoran, Guatemalan, Hondurans. They got their advanced parole, they're getting the EADs. Our guys are so lazy, they don't want to write letters. But I did create a blog recently, guys, which I posted there. You can go to rnlawgroup.com. I want all the people whose I-140 is approved to give an EAD in advance parole. Goodbye to them. And if they have given for the I-130 people, why not for I-140? Please go to rnlawgroup.com. There is a letter that you can write to the congressman. I drafted it and kept it there in rnlawgroup.com. Subscribe to our newsletter so you get all these things. Please write. Not only not counting the family members is one thing. You can also have the people who have I-140 approval should go on to EAD in advance parole. They can get away from these H-1Bs, H-4s. So that'll be easier for them to do it. Please keep writing letters. I put a draft of that in the link that I just provided to you guys right now, in the chat of the YouTube.
Arzu has an approved I-140 and EB2 and filed that 485, has the EAD AP, also filed a downgrade to EB3 and did the transfer of underlying basis. So the 485 is pending in EB3. Obviously that date, priority date has moved back. He's got a 2012 priority date and wants to know, should he move back to EB2? So at this point, we generally recommend only do the transfer of underlying basis when your final action date is actually current in the other category. So if EB2 becomes current under the final action date, then yes, we would suggest doing the transfer of underlying basis at that time. I wouldn't do it in advance because we just have no way of knowing which one is going to move forward. As Raul always says, it's like LA traffic. You move into one lane and it's going to stop, and then you move into the other lane and that's going to stop. So just wait until you get the green light that your final action date is actually current in the other category, then do the transfer of underlying basis.
Jay Shrestha wants to ask and clarify, or there is something miscommunication. Definitely, it seems to be miscommunication, but let me tell you that. If somebody has a STEM bachelor's degree, they get 1 year of OPT, they get 2 years of STEM OPT after their OPT. And if they graduate master's, even though they use the OPT and STEM extensions for the bachelor's, once they get the master's degree in STEM, they will still get 1 more year of OPT and 2 more years of STEM extension. That's possible, that is easy. However, if somebody does 1 master's degree, they get 1 OPT and STEM extension. But if they do 2 master's degrees and then they want to get an OPT, they are not eligible for it.
All right, well, I think we're out of time for today. So thank you all for joining us. Remember, we do have our daily conference call where you can join us on Zoom to get more answers to your questions. And we'll be back again on Tuesday at 5 o'clock Central Time.
And if you want to speak with me, Emily, or any of our colleagues, our appointments are available online. You can block anytime you want to. Our schedule is available online. The link is provided at the video here. Thank you guys for tuning in.